I was just going to say, doesn't access to meaningful legal advice require privacy? You just said access has to take priority over privacy concerns. I don't see it as an either-or.
Well, with respect, Justice Moldaver seemed to present counsel with an either-or situation. And my response to Justice Moldaver and my submission to you is that if it's not an either-or situation, then it's one of balancing in any given situation. But the decision as to whether or not to speak with a lawyer should be given to the detainee. It shouldn't be left in the hands of the police, or we're going to end up in a situation like the one that exists in this case, where they never give him access to a counsel, to a lawyer. They never, he is in police custody for at least 3 hours. They're still there after the blood. They never bother to facilitate his right to counsel.
When do they ask if it's okay to take a breath sample? Do you remember when that occurred?
3:13 a.m.
So before or after the
breath or blood? I'm sorry.
Did they ask for whether it was possible? Did I read that somewhere? That they asked about whether
they
could
doctor.
take a breath? Right. Was that before or after the taking of the blood? Do you know?
Before or after the taking of the hospital blood?
Hospital blood. Well, let me ask you the related question then while you're
I believe it was before, my lady.
It was before.
I believe it was before.
Okay. So my question is, how, if it's okay for the police to delay in implementing a right to counsel pending the right circumstances in which to give the meaningful access that we expect under 10B, what are they entitled to do in the meantime? In other words, does it mean they can never get evidence that is required in a timely way? Do they have to forgo that possibility? I mean, how do they decide what does holding off mean in terms of the obtaining of evidence?
They shouldn't be indirectly, let alone directly, acquiring evidence, particularly from a detainee during this so-called holding off period. And as we all know, even on the facts as found by the learned trial judge, they accomplished their investigative ends, access to hospital blood that wouldn't be, they thought, in my respectful submission, I'm not a conspiratorial theorist, they thought would not attract the scrutiny of the charter. They didn't have to worry about the blood demand blood. They had the hospital blood. And in all likelihood, that's why they didn't worry about even giving them access to counsel after they got the hospital demand blood. They didn't give a second thought to that young man's right to counsel.
The 24-2 argument?
Could be characterized as such, my lady. I'm prepared to deal with 24-2 if...
Well, I don't want to cut you off. Is that everything that you wanted to say about why you thought the majority was right in its approach?
Why don't I just check my notes, my lady? You know, it's exceedingly rare for counsel, defense counsel, to be faced with a set of facts in a 10B situation that are so favorable, that are so clear-cut. I could have provided him with access to a lawyer. I had a phone. I should have provided him with access to a lawyer. If I had to do it all again, I would do it. It is exceedingly rare. I don't see how, on the facts of this case, the trial justice could have done anything but find a violation. And find a violation at the early stage of his detention. As I've stated, he was in the patrol car for approximately a half an hour. with McGillivray with a cell phone. It could and should have been done.
I hear you. You're saying that even if after the hospital tests had been done, and that's when the police go to him and make the demand for the blood sample, if they'd given him his rights to counsel, then you'd still say there's a breach.
Yes, most certainly.
Well, you and I might disagree about that.
I thought that might happen.
So perhaps then you could help us out on 24-2 if we were to accept that the breach happened after the hospital blood samples are taken. If we accept the trial judge's finding as to the timing of the breach, is there a 24-2 way connection between the hospital blood sample and the, I won't call it a breach, but the inability of the accused to exercise his 10B rights at the time the hospital blood sample was taken? Is there a 24-2 argument if we accept the timing of the breach?
Now, if I understand your question, if the 10B violation does not occur until after the hospital blood is drawn,
That's right.
do I have a 24-2
Yes.
argument?
Yes.
I don't think I do. I mean, it's after the seizure of the impugned evidence.
Well, I think what we were putting to counsel earlier was, is there a connection given that 10B rights had not been exercised yet, and the fact that if they had been exercised, he may have chosen not to give
Oh,
blood,
that's different.
and the fact that police were there ready to and able, were there, not colluding, but there, so that they would be able to establish circumstances to take advantage of that. That's the question that I was asking of the appellant,
All right.
which is, I'm just asking you, is that a possible route?
Yes. Yes. Yes, it is.
Or is it a problem because of the timing of the breach, which is what I'm concerned about here, if the timing follows it?
Let me just add to that. What do you think the timing of the breach was?
Right at roadside. He's in that car for a half an hour. He's clearly asserted his right to counsel. The available means of facilitation of counsel is there, and it's not used. And we know from the officer that it could and should have been used. And if you had to do it all again, it would have been used. It has to have happened at roadside. I mean,
When you're finished answering Justice Karakatsanis, I have a follow-up question for you on that issue.
And mine was if the violation is after the hospital blood is drawn.
I think you'd still have to take a look at the process. I think it's this Court's decision in Whittier, if I'm pronouncing it correctly, which said that you have to look at the process to see if the acquisition of the impugned evidence is part of the process, and in this case, the investigative process. So it would take a bit of retrospective analysis, but the taint would still be there. The taint arising from the 10B breach would still be there sufficiently, in my respectful submission, to trigger Section 24-2. I think we have to go back and take a look at why was Constable McNamara there in the first place? She was specifically assigned to track the blood. And that's something that caught Justice Berger's decision during the course of the proceedings in the Alberta Court of Appeal. I believe that Justice Berger initially thought that she was there to track the blood demand blood, but she was there specifically to track the hospital blood. Now, why would her focus, why would her concern be on the hospital blood when the police can easily avail themselves of the blood demand blood, which one would also think would require considerations of continuity? So she's there for the specific investigative purpose of conducting an investigation relative to the hospital blood. That's why she's in the hallway. That's why she's in the treatment room with the respondent. That's why she's interacting with the nurse. And according, I didn't know if I'd go there or not, but according to Constable McGilvery, you'll recall he created a video and words, Constable McNamara was receiving these vials one by one, all 5 of them. Now, she testified to the opposite in cross-examination, but you may recall, and some of you may not, but the Crown, notwithstanding an order excluding witnesses from the proceedings until such time as they were called to testify, the Crown sent an email to Constable McNamara flagging that handling of the vials issue.
Are you finished addressing Justice Karakatsanis'?
I believe I am. Thank you.
If the breach occurred in that half hour in the car, does it even matter, in your view, what happened in the hospital?
No, it doesn't.
So it's a breach that could not have been fixed in the hospital?
Well, if they had...
Or was there an ongoing, once there's in your view, a breach in the car, did it continue in the hospital? In other words, does there have to be a moment in time at which it crystallized and thereafter could not have been rectified, or was it an ongoing breach pending until the evidence was taken?
It was an ongoing breach. It was a breach that started in the rear of the patrol car at roadside during the half an hour that we discussed earlier. And it was actually a breach that didn't end with the taking of the hospital blood, and it didn't end with the taking of the blood demand blood. The breach continued until the police chose, about 3.5 hours after they apprehended the young man, to walk out of that hospital. One officer with blood demand blood under his arm, and the other officer with tracking information germane to the hospital blood under her arm, without giving a second thought to the constitutional right of that young man to have access to a lawyer.
Anything else you want to add on the Section 24-2 issue?
No.
Anything else you want to add?
I can just check my notes, please.
Yes,
Thank you.
sure.
I do note that I have about 10 minutes left, but I really have nothing to add. Thank you.
Good advocacy tactic.
Thank you very much.
Good morning. Good morning, Justices. The Canadian Civil Liberties Association intervenes in this case because it has concerns about watering down rights to counsel. And I'm going to suggest that what you've been presented with, both in argument today and from the decisions below, is a version of rights to counsel which effectively does that because it fixes the time of rights to counsel at a later time than it ought to. So, for instance, the question, I think, which has been debated this morning is, when does the implementation of rights to counsel arise? As questions that were put to my friend, Mr. Fagan, the question is, does it arise at the roadside? Does it arise at the hospital? Does it arise at a later time? And I'm going to suggest that there are many reasons why rights to counsel arises as soon as the detainee or the arrestee says, I want to speak with a lawyer. At that point, the law says he has a right to speak to a lawyer. There are many good reasons for that. Now, the first is, at the most simple and basic level, The text of Section 10b says that. Section 10b says that the arrestee, the detainee, has the right to access to a lawyer without delay. The text of Section 10b does not say they have a right to speak with a lawyer at a reasonable opportunity. It doesn't say at a time when it can be done in the most efficient fashion. It says without delay, and this Court has said consistently that without delay means immediately. And that is to say that we can comment on the facts of this case as it's presented to you when the respondent says, as he did at the roadside, I want to speak with Mr. Fagan. The law suggests, imposes an obligation on the police to put him in touch with a lawyer then. There may have been practical reasons why it couldn't happen. However, the law suggests that the Section 10b right arises at that point in time and not later.
What happens then when there are, and if you wouldn't mind just staying away from the facts, I know it's sometimes hard. What happens then when it is not, if there were a case where it was found not to be reasonably possible to provide that implementation at the time it arises?
Well, in my respectful submission, the analysis would proceed on the basis that the arrestee has indicated a wish to speak to a lawyer. The right arises then. However, the remedy might be affected. In other words, it might sound in Section 24(2). A court might very well say he indicated a wish to speak to a lawyer, but this speaks to the collection of evidence and whether that evidence should be admitted at trial. There might be additional concerns about, for instance, Justice Moldaver, you asked this morning about Milne in Section 1. In other words, if someone asks to speak to a lawyer, but there are other reasons why they can't speak to a lawyer, it might very well mean that the evidence can't be used against them. And so
— But there might be other concerns, too. The person might be injured in an accident. We don't know whether their mind is okay. I mean, you can't just — I mean, the police officer has to make calls, and this was a very serious accident, it seems to me. And I mean, the next thing you're going to know is, oh, yeah, you've got the right to counsel. Go ahead, here's a cell phone. And then we get into court, and, oh, my God, my head was spinning. I didn't know what I was doing. I didn't have medical attention. Mr. Rose, you know where these things go. So I think it's a little bit too stark just to say the guy at the roadside says, I want a lawyer, that's it. And if you don't give him a lawyer, there's a breach, but maybe it's 24-2.
Well, there will be many cases, Justice Moldaver, where no evidence is collected. And the difficulty with fixing the point in time at a later and fixing the reasonable opportunity definition is that effectively, in my argument, it allows the police to decide when rights to counsel should happen as opposed to the law.
Oh, that's why we have judges. If the police have made a decision and the judge says it's an improper decision or an unreasonable decision or one that they weren't entitled to make, then you have a breach. But you can't, it just seems to me, we're not handing all this over to the police.
Justice Moldaver, we may not be at cross purposes. All I'm suggesting is that the law imposes, or that right arises, it crystallizes, as it were, when the person says, I want to speak to a lawyer. Because we know there are many cases where the arrestee simply doesn't say that. The implementational aspect might not arise. The question for this Court to determine, I'm going to suggest, is when does the implementational obligation arise at law? There may be practical difficulties with the implementation, Justice Moldaver, as you've indicated. And I cannot disagree with your proposition that trial judges are very well suited and placed to sort out what the effect of that breach is. But, for instance, as the trial judge said below, there was no right to counsel breach because there was no reasonable opportunity.
In normal cases of breathalyzers, as you know, the person's told that their demand is made, they're put in the back of the cruiser, they're not given their right to counsel right there, they're driven to the police station. So, I mean, that could be 20 minutes. Of course, on your theory, there'd be a breach. The law's never gone that way.
On my theory, Justice Moldaver, if that happened and there was no evidence collected, it would be a moot breach. However, there will be cases, I'm going to suggest, where someone does indicate a wish to speak to a lawyer at arrest. They identify the lawyer, and evidence is collected. And it might not be a man-in breach, as we call it, because it might not be the police that gather the evidence. It might be evidence collected by a third party, as we have in the case at Barr. And in my respectful submission, if we fix right to counsel, the implementational obligation, when the detainee says, I want to speak to a lawyer, then the law suggests that that evidence is collected by the third party during the course of a rights to counsel breach. Whereas here we have two competing versions. You have a trial judge and you have a dissent in the Court of Appeal below that say, well, the rights to counsel doesn't arise when the detainee says, I want to speak to a lawyer. It arises when the police can reasonably make that happen. And I'm going to suggest that that introduces a lack of clarity for the participants. In other words, the police must determine on the ground at the time, can they make a reasonable opportunity? How far do they have to go? From a trial judge's perspective, I'm going to suggest that it's easier if the law imposes that obligation when the detainee utters those words. So that's why I suggest, I'm going to go so far as to say there's a false dichotomy here. You don't have to determine whether the rights to counsel arises later on or what happens. It's very easy to say the right crystallizes when the detainee says, I want to speak to a lawyer, and then leave it to trial courts to sort out whether or not that was implemented in a reasonable amount of time properly. As this Court has said, it is not simply a question of workable definitions. It is a stable, predictable definition, as this Court said in Subaru. As I've indicated, and it's paragraphs 40 through 42 of Subaru have been argued this morning consistently. I rely on paragraph 42 of Subaru where the Court says what right to counsel requires is a stable, predictable definition. And a delay in implementing that right, as this Court has said and Justice Binney said in Sinclair, fits uncomfortably with the constitutional text. So in my respectful submission, that's when rights to counsel arises, and that's what I'm asking this Court to find in terms of when that right arises. So proceeding on, this Court has heard many submissions about the practical difficulties and whether or not you should have half rights to counsel or not. I'm not suggesting this Court change the content of rights to counsel, which really is privacy. What I'm asking this Court to say is that when a detainee says, I want to speak to a lawyer, there should be some obligation to make that happen, and the police should turn their mind to it. So, for instance, it might require, as the Court of Appeal in Ontario said in George, that the officer ask the detainee, do you have a cell phone? There seems to be no difficulty with that. It might require, if it's in a situation where there is no safety concerns, that happen at the roadside. If the officer has genuine safety concerns that says that shouldn't happen there, well, that's for a trial judge to determine whether that was reasonable. However, it should be incumbent on the police to make efforts to make that happen. And as I've indicated in paragraph 11 of my factum, hospitals are not spaces where privacy cannot happen in terms of rights to counsel. There are many cases, when I don't need to go through them right now, but they're in paragraph 11 if you turn to them on my factum, where police have consistently provided rights to counsel in situations very similar to the case at bar. And trial courts have been satisfied that privacy concerns and timing concerns have all been respected. I have 20 seconds left, but I don't need them unless this Court has questions.
Thank you, Mr. Russell.
Thank you.
Mr. Russell, any reply?
Just very briefly on some of the evidence you asked about. With respect to the timing of the blood demand, it was after the hospital blood had taken Constable McGilvery, then asked